Good evening and welcome to Monash Law in Conversation. I'm John Faine, and very much a big welcome to everybody in the room and online for the first of our season 2022. First, I'd like to acknowledge that we're on the lands of the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past, present and emerging, and to any Indigenous representatives who are here with us, First Nations people in the room. And on a personal note, I'd like to express my impatience for a treaty or treaties in order to at least start to repair some of the damage of our colonial past, without which, it's my personal view, we as a nation are a bit stuck and can't move on. We do have an audience here at Monash Law City Chambers, and thank you all for coming along. Make a noise, let people know online that you're here. And could I ask you please to pay us the courtesy of just quickly and discreetly checking that your mobile phones are either off or silent, and the first one that rings will go tut tut, and the second one will glare at you, and the third one, I've got a bucket of water here, and your phone will go in the bucket of water, so please. Could you also welcome Mark Dreyfus, KC now, and MP, who is the Attorney General of the Commonwealth of Australia. And is our first victim for 2022. Next week, Amanda Mackenzie, who is a Monash alumnus, who is the current chair of the Climate Council. She's one of the founders of the Climate Council, and she'll be in the chair at this same time next week. Mark, it's a very loose format. It's in conversation, and we'll try and keep it conversational. You're the Attorney General, you're the first law officer, but why did you even become a lawyer?
I became a lawyer. It's a good first question, John. It seems a long time ago, but why did I become a lawyer? I did law because I did quite well in Year 12, which is a common reason for doing law in Australia. Not really decided what I would do, but thinking, well, I got the marks, I should go and do law arts at the University of Melbourne, sorry, Monash. And I did that. I did graduate and did not initially go to work in the law, and actually went off into a slightly different direction, thinking I might not practice, which might sound a very unusual thing to say if you're the Attorney General and someone that was a barrister in Melbourne and a silk. But initially, at least after graduating from the university, I went to work for the Land Council in the Northern Territory, Northern Land Council, as a field officer, not as a lawyer. And
what did you do?
I went out bush.
Where'd you go?
I went right through Arnhem Land, down to Borroloola, over to the west side, Port Keats, now Wadair.
And a very troubled town.
And my job was many and varied, because the Northern Land Council in those days was a very, very small organisation. It's now a very big organisation, one of the really important organisations in the Northern Territory. But at the time it was small, and my jobs included organising for the first sea claim in the Northern Territory around Milingimbi and the central Arnhem Land coast, doing part of the negotiation for the setting up of Kakadu National Park. Shows how long ago it was. And
because we're old.
Negotiating with the Ranger Mining Company, working on land claims, a range of negotiations, and working on claims, I suppose you could call it. And it actually showed me that the law could be useful.
Did you doubt that?
I did.
Why?
On leaving university, I wasn't sure. I thought I wanted to work more in social justice, perhaps in some kind of environmental area. And it showed me that perhaps going back to Melbourne and getting a law degree, getting admitted, would be a useful thing to do.
And we first crossed paths, I think, when you came back and volunteered at Fitzroy Legal Service.
We did.
So mid-1980s. And I love telling people, they say, oh, the Attorney General, yeah, he was one of my volunteers. And you very quickly, though, pivoted away and ended up as a ministerial advisor to Jim Kennan, the then Attorney General in the Victorian reforming Labor government of John Cain. But then, having dabbled in the political sphere, you went back to practice at the bar. So what were the decisions along the way that You started off doubting it, then you went into the political side, then you went into the practice
Well,
side.
I came back.
And you went back to being
Did the College of Law, and got admitted, and got offered a job by one of the big Melbourne firms.
Was it Mills, I think?
Then called Mull, Hamilton and Derham.
Yeah.
Again, ancient times. No one in this room will even remember that. It became Freehills during the time I worked there for a bit under 4 years. And it was a taste of what big commercial work looked like, doing mergers and acquisitions. I got offered a job by the then Attorney General, the late Jim Cannon, and it lifted me out of being a solicitor, so I went to work in politics for a couple of years. And he encouraged me to be a barrister. He was a barrister, and he thought that I might do okay. And so partly on his advice, I think he thought I wasn't all that suited to politics, which who knows, maybe I've learned something since, but he thought I would benefit by being a barrister, and I did go and be a barrister and did that for 20 years and enjoyed it very much.
But you got involved in the Labor Party even way back then. In fact, you
I joined the Labor Party when I went to live in the Northern Territory.
Yeah, and you did a number of key reports of all sorts of things, including branch stacking and how to reform the membership and all that sort of stuff, which, looking back, it's hilarious that it's still an issue in the Labor Party today.
It's been a problem for a long time.
Yeah.
Some would say it still is.
Your recommendations were there to fix it, but let's not get stuck on that because
we're not here to talk about the Labor Party.
No, nobody wants to. So tell me about the Labor Party. So back to Jim Cannon was a reforming Attorney General. Is that how you see yourself in this role now?
I do. I often think about Jim Cannon. He was a tremendous reforming Attorney General and had a sense of what a progressive government, what a Labor government should be doing in the law. And I think often about Jim's zeal for reform, energy for reform, the idea that you must not waste a day in office. And I try to apply that. I had a very short period of 229 days, but who's counting? The last time I was Attorney General.
At the end of the
at the very end
Gillard
of the
era.
Yeah, at the very end of the Gillard and then into the second Rudd government, and wasn't long enough for me. It's one of the reasons I've stayed in it. I've got the great good fortune and privilege to be the Attorney General of the Commonwealth again, and sometime around January I will have completed the same length of time that I had first time round, and I'm aiming to make it quite a lot longer. Perhaps not emulate Billy Hughes, who was Attorney General of the Commonwealth 4 times and Attorney General for 13 and a half years. I'm not aiming at that, but I am aiming at certainly this term of serious reform. There's a lot to be done.
I think your wife, Deborah, will be pleased to hear you publicly state that you're not aiming at 13 years as the Attorney
Indeed.
General. In the time, and impatient as you are, and I've witnessed that over particularly the 9 years in opposition where you've been itching to get things done, you've already announced what would have to be the most ambitious program, starting with the National Anti-Corruption Commission, going right through dealing with what you regard as now an out-of-balance judiciary from political appointments, the AAT and so on, and then law reform, and off it goes. No one can realistically expect to achieve everything that you're saying is on your shopping list. So do you have priorities?
It may be that I will not complete every one of these projects that are projects of our Labor government, but that's not a reason not to start. And some of them are going to be able to be completed. The National Anti-Corruption Commission has gone so far much better and much more quickly than I would have dared hope, that I have been able to bring it to the Parliament. It's been to a committee, through a committee process. That committee will report on the 10th of November. I'm very hopeful, because of the reaction right across the Parliament, that it is going to be supported right across the Parliament. And I think that's partly a product of, in a sense, the happy accident of the former government bringing forward a terrible model in the last term, which the silver lining in that cloud was that we have been able to have a debate about what a really good National Anti-Corruption Commission looks like. So there's a project that's gone more quickly and so far better. It hasn't passed the Parliament yet, and I'm not getting ahead of myself.
So we're in committee stage. Let's get down to the guts.
We're getting the report this coming Thursday.
Sure, and you're already getting feedback. I'm sure you're in regular contact with those who are in charge of fine-tuning this insofar as we can describe a committee's work that way. Exceptional circumstances for a public hearing. Are you rethinking it?
I'm going to wait to see what the committee says in its report. But there were conflicting views offered during the course. I watched the committee. I read all the submissions to the committee, and I watched the 4 days of the committee hearings closely. And there's competing views about this.
You very deftly didn't answer my question.
Well, I'm not going to commit. I'm going to wait to see what the committee says, because there's a real importance, it seems to me. We've slipped away from the rest of my law reform agenda, John. I hope we get back to that. But for me, there's a tremendous importance in seeking to achieve whole Parliament support, the whole of the Parliament supporting it. If we can get to there, and I doubt that I'm going to get complete unanimity. There might be a couple of senators who've already indicated they don't propose to vote in favour of the National Anti-Corruption Commission. But if we can get the crossbench, the Liberal Party, the National Party, and the party of government, my party, to vote for this legislation, that will give confidence to the whole community that almost the whole Parliament supports this very important new national institution. And I think that's a very good thing if we can get to there. It provides some guarantee that it won't be torn up by an incoming government of the other party. But more importantly, it provides confidence to the whole community that we've got the model pretty right.
So if indeed, and I know you've previously refused to confirm this, but if the deal was done to get the Conservative side of politics to support it, if public hearings were only under exceptional circumstances and in public interest, but the bulk of submissions are coming from people saying, no, public hearings have to be according to a lower threshold, how do you reconcile those and coming up with something that everybody will support, as you just said, is your ambition?
People make compromises in politics.
You do or they do?
Everybody does. It's the nature of democratic parliaments that everybody in the parliament might have to give up something in order to reach a consensus view. And I think another silver lining of the cloud that the Commonwealth is the last jurisdiction to get an anti-corruption commission. We've been able to look at 8 anti-corruption commissions in the 6 states and both territories, most of which have had an anti-corruption commission for 2 or 3 decades. It's enabled us to look at what the best features might look like. And it's also enabled us to see that you can still have a workable anti-corruption commission, even if it's got some different design features from, say, the one that's operating in Queensland or the one that's operating in WA. And I think it's given people an acceptance that, okay, they personally might be designing a National Anti-Corruption Commission that had to have that feature, but they can understand that minds may differ. And they're prepared to accept that we in the government have landed on a slightly different model than what they might have hoped for. But they'll still vote for it.
At the National Press Club, you were at great pains to answer questions about referrals to it by saying you don't direct it, you don't tell it what to do, it's totally independent of government. The Attorney-General of the day has no greater say over how it works than anything else. But surely not all referrals are equal. A referral anonymously from a member of the public is not the same when it arrives at a National Anti-Corruption Commission as a referral from the Attorney-General of the Commonwealth of Australia, is it?
I'd accept that, but the bill provides a referral process. Mm-hmm. So where a minister or a secretary of a department becomes aware of something that will constitute serious or systemic corruption, they are obliged to refer it.
Sure.
And in that instance, I'd be expecting, because that is the source, it's come from a secretary of a department or come from a minister, I would be expecting the Anti-Corruption Commission to take it very seriously. But equally, I'm expecting this Anti-Corruption Commission to have processes that will take seriously all complaints of substance.
It
And
can't investigate everything.
It certainly cannot.
This Anti-Corruption Commission, I will predict confidently, on day one, will have an incoming mailbag that will look Santa's Christmas sack look pretty thin in comparison. It will be huge. Everyone with a grievance, some legitimate and some fantastic in the general, genuine sense of the word, just completely absurd, will be visited upon the Anti-Corruption Commissioner and their team, who are going to be somehow expected to sift and sort within the limited resources that they get, even generous as you say they are. How are they going to do that?
That sifting and sorting process is a really important part of what these anti-corruption commissions
so it's like
do.
Triage. How do they work it out?
I've met with and spoken with many of the anti-corruption commissioners, present and past, and they have teams of people whose job it is to sift and sort and triage, and they make decisions on the basis that they cannot possibly investigate everything. It is not like the court system, which is obliged to hear matters brought to the court. That's a different setup. These anti-corruption commissions make choices. They've got finite resources, and they will choose the more important things. They might choose, I've seen in the past that some of the state commissions have chosen to investigate repeatedly in particular areas because they think that that's a good use of their resources. They focus on a particular part of administration. Others mix it up more, and that's a choice that they make. There's another characteristic of these anti-corruption commissions. They're pretty dependent on the identity of the commissioner and the deputy commissioners. That has the capacity to shift emphasis. It's not that one emphasis is wrong and another is right. It's just it's a kind of fact of human nature that if you have particular people in the job, they're going to have a particular focus.
It's also in the nature of the beast that they're going to want to make their mark, and they're not going to knock back a referral from the government of the day that created them if it's said this is something we want you to look at. Now, the argument about it being politicised is that if there are things in Australian recent political history, and tempting as it is to be mischievous and throw you certain examples, everyone will have an idea.
You'll get the same answer, John.
I totally understand. I'm not going to be as trite and as cliched as that. But if you, the Attorney General, refer some recent political events in Australia's past to the Anti-Corruption Commission as its first job, it will immediately characterise it as a political hit.
Which is why I have refrained absolutely studiously from saying, in answer repeatedly to journalist questions, this has been going on for years now, tell us please, Mr. Shadow Attorney General or Mr. Attorney General, is this, and then a particular allegation is put forward or an event is described, will this be investigated by the National Anti-Corruption Commission? And I think if you look back, you'll see not once have I answered that question.
And you're not going to tonight.
And I'm not going to tonight, but I'll say why. It's really important that the Anti-Corruption Commission be understood not as a partisan body. It is not there to do the bidding of the government of the day. That was one of my major complaints about the former government's model. It could only act on referral from the government. And that's almost a contradiction. It has to be independent. Its independence is demonstrated by me saying, I am not going to dictate its work.
There's a whole lot more than the Anti-Corruption Commission we want to talk about, but a few more specific questions.
Yeah.
Will it have the power to exchange information in confidence with state anti-corruption bodies and do joint investigations?
Yes.
Will it have the power to exchange information with state ombudsmen? For instance, in Victoria, we've recently seen the Victorian Ombudsman and the IBAC conduct a joint operation.
Not formally, but I expect it to enter protocols of various kinds with other integrity bodies across the country, which will include state integrity bodies. Its primary focus is on the government of the Commonwealth. That's why there's reference to every one of the existing integrity bodies at the Commonwealth level. There will be cross-referral mechanisms. They are in the bill. But in addition, I'm expecting it will develop protocols over time, so it will need to have a way to deal with state police forces. it will need to have a way to deal with state ombudsmen or other agencies.
Let's move on away from the National Anti-Corruption Commission, although I've still got lots and lots of questions, but otherwise we'll end up spending all of our time talking about it, and that's not the purpose of this conversation. You're talking about law reform generally. Australia's Law Reform Commission, I'm not wanting to be unkind, and I'm not wanting to characterise it by comparing it to its predecessors, but the last 9 years in particular, the previous government had given it less and less to do and less to do it with. You've announced an increase in its budget, but do you regard its work as being vital and integral to the legal system, or is it within your department that law reform gets driven?
I think both. And I think that the Law Reform Commission is much reduced, or has been much reduced over the last 9 years from perhaps earlier decades. Think Sackville, think some of the really major reports that we can all remember that the Law Reform Commission has produced on privacy, on which led to the Privacy Act, on secrecy, on a whole range of things that were really landmark reports. And I do want to put more resources into the Law Reform Commission because I think as a process, it's got an independence. It's often involving serving judges. It's pretty much the only way in which a serving judge can assist with the governance of the Commonwealth, because serving judges, by and large, just sit in court. But traditionally, we've had 6 or so federal court judges serving as part-time commissioners on various things. But in the last few years, it's had fewer and fewer resources. And it can only do so much if it's only got a handful of staff. It needs to be a larger organisation in order to fulfil its function. Equally, there's law reform to be done in the Attorney General's Department, and it's done in a different way, because clearly it's going to be more directed to government priorities. It's going to be, I don't expect the Attorney General's Department to act in an independent way. It acts at my direction. And that's a different way of going about law reform.
So sometimes law reform commissions have annoyed and irritated, even undermined government policies and progress.
I'm up for that, and just as I'm up for debate from the Human Rights Commission.
Next on my list.
Its function is to raise issues. It said so in its act. And I was very puzzled at the attacks that were made on Professor Gillian Triggs when she was president. All that she ever did was to go about her function that's conferred on her by the Australian Human Rights Commission Act. In a similar vein, so not only do I support the Human Rights Commission speaking out, I support the Law Reform Commission producing independent reports, and I support community legal centres, to go back to our roots, John, being able to speak, which is why I've set in train a process to remove the dreaded gag clauses from the funding arrangements for community legal services.
Now, for people who aren't familiar with that, explain how that works and what effect it's had.
The Liberal government under Tony Abbott and George Brandis as Attorney General put into the funding contracts that community legal centres have under the National Legal Assistance Partnership arrangements, where they get money from the Commonwealth. It's a condition of getting money that they are not allowed to speak on matters of law reform. Now, that seems to me to be an absurdity. Very often, community legal centres are best placed to speak out on matters of law reform because they've seen it. They're at the coalface. They can see how simple changes to the law might in fact remove the need for a whole lot of work that they are presently bogged down in. You've only got to look at the reforms made to residential tenancies in Australia, which were driven by tenants' unions and community legal centres saying we can't any longer continue under 19th century landlord and tenant law. We've got to do better, and that's where the Residential Tenancies Acts came from. Similarly, consumer affairs laws were very radically reformed in the 1970s and 1980s as a result of agitation from people working in the community legal centre movement. So the idea that the Commonwealth Government should, as a condition of funding these small community legal centres say you are not allowed to speak out, I see as an absurdity, and I've written to all of the state attorneys general to ask them to remove, because I need their agreement. It's a national agreement that we have with the states and territories to fund community legal centres, but I'm not in much doubt about where it's going to end because I've already got preliminary agreement from the attorneys general.
Just because I've got a reputation for mongrel questions, you do realise it was Jim Kennan who first put a clause like that into a funding agreement for a community legal centre.
You are a mongrel. But
so
whether it be
your
him,
great mentor when I was at Fitzroy,
whether it be him or not,
telling us probably when you were advising him that we were to stop biting the hand that feeds us.
Well, I've got a different view. It's the same reason that in this budget you'll see a restoration of very limited funding, not to the right level yet, but restoration to very limited funding to the Environment Defenders Office and Environmental Justice Australia,
and your
which
colleagues...
is funding that's been provided by the Minister for the Environment in her budget. But the principle's the same. You might say, well, those organisations sue the Commonwealth Government, and they do.
Yeah. And your colleagues appreciate that that's actually part of the checks and balances of the Westminster system. That's part of how the system's designed to work.
Well, that's my view of it. I think that
Do you win that debate around the cabinet table? Or do they say, why the hell are we funding these organisations to try and...
I'm not going to talk to you about what happens around the cabinet table, but I'll point to the outcome, which is that in the budget of the 25th of October, in the part of the budget that Tanya Plibersek is responsible for, you will see a small amount of funding, some $8 million, that is to go to the Environment Defenders Offices and Environmental Justice Australia, which is, from my point of view, a good thing, and the government has made that decision.
All right, we're nearly halfway through. Mark Dreyfus, the Attorney General, is my guest in conversation. I'm John Faine. We're at Monash Law's City Chambers. We do have the capacity to include your questions, including those of you who are joining us online. And if you want to use that capacity, you can send your message. It'll be moderated and put through on a monitor here, and I'll receive that then too. Although I've got pages and pages of questions for Mark of my own, but I'm happy to include suggestions that come from the combined wisdom of the crowd, which is usually something that's quite overwhelmingly powerful. Speaking of legal aid, it's a mess. How are you going to fix it?
The National Legal Assistance Partnership was put in its current form, was created by the former government in 2020. It goes for a term of 5 years. And one of the unfortunate things that happened, I was very critical of it at the time, was that the former government rolled the Indigenous Legal Assistance Partnership, which had existed in a separate form. This is the funding arrangements for Aboriginal and Torres Strait Islander legal services. It was rolled into this pretty large agreement, the National Legal Assistance Partnership. That's a mistake as far as I'm concerned, but the National Legal Assistance Partnership is reviewed midway through. The review will start at the start of 2023 and be completed by the end of 2023. And I'm expecting there to be substantial changes when we get to the next iteration of the National Legal Assistance Partnership.
You're not going to interfere in the meantime? You're not going to foreshorten the
process?
process?
No, I'm going to look at whether or not changes can be made in the interim. But
what sort of changes? Just funding or organisational?
One of the changes is funding. Another is looking hard at the relationship between the different parts of the legal assistance sector and how they interact. So
what does that mean? I'm sorry.
Well, legal aid commissions do some of the work. They do the bulk of legal assistance work in all states and territories.
In-house. And they fund private practitioners.
They fund legal aid commissions. Both have their own solicitors. They fund duty solicitors. Sometimes they have contractual arrangements with community legal centres. They brief the private bar, and they brief private firms of solicitors to fulfil duty roles at some courts.
Particularly in regional Australia, where there's no alternative.
And it is a very patchy, different set of arrangements in different states and territories. So one of the things that I'm going to look at is whether we can get to a greater evenness of provision of service, whether you are in the regions or in the cities.
How do you do that?
And it's about,
and how do you avoid it becoming lowest common denominator when you try and make it uniform?
People have said for many years that the level of assistance that's provided is too low.
In the lower courts?
Everywhere. There was a huge report done by the Law Council of Australia called the Justice Project, which was a 2-year project supervised by Fiona McLeod as president, and it landed, sadly, its day of launch was on the day that Malcolm Turnbull lost office as Prime Minister.
Oops.
Which just sometimes happens in the political world. That
you can spend 2 years building up
another event. I went to its launch. It was in Parliament House in August of 2018, and despite the fact that the former Chief Justice of the High Court of Australia, French, was there to launch this excellent report on the inadequacy of legal assistance funding in Australia, it did not get one jot of coverage for obvious reasons. It was
probably not a single journalist in the room.
Yeah, it was a shocking coincidence of events, and yeah, I imagine not many journalists came. In fact, probably none.
So how do you go about reforming?
But I was just going to say the Justice Project, like a number of reports before it over the last decade or so, pointed to a very serious shortfall in legal assistance funding by both state and federal governments. And this is a joint project. The legal aid commissions are primarily funded by state and territory governments. I saw in the way in which the former government was choosing to approach this as something that was intended to lead to a retreat by the Commonwealth altogether from legal assistance funding. And that's why more and more the National Legal Assistance Partnership was delegating responsibility to the states and territories. So when I say it's not just about the level of money, it's also about the way in which we choose to organise legal assistance in this country. And that's something that perhaps I will be able to do something in the short term, but in the medium term, it's going to be the review of the National Legal Assistance Partnership that will have to achieve long-term change.
Is there one state legal aid body that you think is the model for the rest?
I think New South Wales has historically funded its legal aid, its legal assistance sector better. They've still got something that I think a lot of Victorians would look with some surprise at, which is a much greater civil law legal assistance section.
Which has virtually disappeared in Victoria, except for Social Security.
Sadly, this is not a criticism of the excellent work that the Legal Aid Commission of Victoria does, but it does not any longer do much civil work. It's set its thresholds for assistance at a level where you're just not likely to get assistance for a civil case. It focuses on criminal work. And if I had to make a choice between the priorities, I'd say, well, it should focus on criminal work. I'm not doubting their choice, but that's over a long period. New South Wales still does a lot more civil work, and that's a good thing.
So the question of legal aid is tied integrally with the cost of litigation and the cost of criminal trials as well. And this question from one of our online audience members, summing it up beautifully, justice is only for those with money and time. Is Australia heading that materialistically valued way? Are we heading down that path because of the cost of going to court?
We do have a system in which if you are charged with a serious criminal offence in this country, you will receive legal assistance. You will receive representation. And the High Court has said repeatedly that it is not appropriate for any court to proceed with a serious criminal trial unless the defendant is represented. So that's a marker of a civilised society, and as far as I'm concerned, expanding legal assistance so that people in civil matters who can't otherwise afford a lawyer can get some level of legal representation, I think is also a marker of a civilised society, and that's a project that's unrealised as yet.
I'm kind of driving in the other direction though. What can you do to try and reduce the amount of time that trials take, whether civil or criminal? It's extraordinary, and some of the cost blowouts that then the system has to try to accommodate
Mm.
arise from what still to any outside observer seem like absurd and arcane rules of evidence and procedure and trials that take so long. I mean, just a generation ago, a murder trial would typically go less than a week, and now they go for months.
I don't know that it's quite right to say a murder trial would go for a week, but trials used to be quicker. I'd agree with that.
And yet,
we're not going to solve this here, sitting in conversation, John.
But is it something that is a justice review, given that there are now many alternative models? You know, people question the adversarial system and say it's unsustainable. Do you entertain any thoughts along those lines?
Most people charged with serious criminal offences in Australia plead guilty. That's just a fact of the criminal justice system. And trials that run, judges and barristers wrestle with exactly what you are talking about. No one wants criminal trials to go for a day longer than they should. Everyone involved recognises the burden on jurors if the trial goes for too long. And there's a real effort made to make trials run shorter.
I asked if you are losing, are you in any way questioning the adversarial system? Does
No.
it even cross your mind?
No,
What about restorative justice models?
I like restorative justice models, and I think we should work harder at all kinds of therapeutic approaches, restorative justice ideas involving victims somehow in the criminal justice system, which we don't do well and haven't done at all until relatively recently. One of the commitments in the budget from last week is for the investment by the Commonwealth in justice reinvestment in every state and territory, building on what appear to be early successful outcomes from the Justice Reinvestment Project in Bourke, very indicative early outcomes from a Justice Reinvestment Project in Halls Creek in the Kimberley, and we think that it's a model that is worth looking at, and we're intending to work with communities right across Australia, particularly Indigenous communities, to see if we can get more justice reinvestment, which is simply, for those who are not familiar with this idea, an idea that you look at spending money on diversion programs, spending money that would otherwise be spent on imprisonment or on prosecutions, spending money on diversion, on therapeutic approaches,
Case management,
closer management, closer assistance, more support, anything that can move people away from that charge, conviction, jail, repeat, which we see all too often.
That involves a cultural shift. And we're speaking in a law school where people by and large still are being, and it's not a criticism of the law school, it's the same right across all the law schools in Australia, people are still taught to prepare for a career, given that many at least dabble in practicing when they graduate, although not many still are there years and years later, but they're prepared for a career working in a system that is still like the one you just said you're kind of almost wondering about whether it's sustainable or not. And there's not a lot of training for new graduates in these alternative models of dispute resolution, criminal or civil.
Some would argue that the law course is not a lot of training for anything much, and I mean that in the politest possible way. A lot of law subjects are directed to something that will be useful if you are planning on a career of appellate advocacy in the High Court. Because
come on, we learned what happens if a steam train sets fire to a haystack. I mean,
there you go. We learn about cases. You know, the law is taught through the study of cases, but there's not a great deal. It's got better since the ancient times when you were in law school. And we've got probably more practical training happening in law schools, more involvement with options at least to go and spend some of your course time at a community legal centre.
Or in a clinical program,
or in some kind of
Monash in
clinical
particular
program.
is pioneered. Yeah.
And some courses now that teach you about alternative dispute resolution. So it's got a little bit more practical, but the law course is still one where you are mainly learning theoretical legal concepts. You're learning a way of thinking. It's useful, how much the law course should be devoted to what happens in practice, it's a long-standing tension. I think it's got a bit better though. I think that law graduates now know more about the practice of law than was the case when I graduated.
I think it's a bit like learning to drive. You only really learn to drive when you're behind the wheel and there isn't an instructor sitting or anxious parent sitting next to you. That's when you work out what things are. But let's move on. Are there too many law schools before we leave legal education? We've got enormous numbers of law schools in Australia now. I think 19, I think, is someone in the room will correct me if I'm wrong, but I think
I would argue not. I think that the law degree is a wonderfully useful qualification. And there are hugely more legal graduates than there are places in the profession. But many people doing the law degree have no intention of practice and they won't practice. But they know that the way of thinking, what they learn in law school will be useful in a whole range of other careers. And equally, I often say to law students, if you want to practice, you will be able to. Notwithstanding the apparent disparity between the number of places available for first-year lawyers and the number of graduates every year, it's in excess by a factor of about 4 last time I looked. If you really want to practice, you will be able to practice because there's turnover. People start in the law and find that it is not to their liking. And that's a good thing, that people start off as solicitors and find that that's not for them, or they start off as barristers and they find that that's not for them, and they'll go off into some alternative career. What I'm not in doubt about is that graduates of Australia's law schools are wonderfully well qualified to be in the workforce and will find terrific employment. I very rarely meet people who are law graduates who say, I wasn't able to get a decent job. It's usually the reverse. They attribute to having a law degree. I sound like I'm advertising for Monash, or for law schools. But I do think that it is a really good qualification.
Yeah.
People like to point to the Parliament, for example. They say, oh, the Parliament's full of lawyers. I usually argue with that proposition because, in fact, there are very few people who have practiced law in the Parliament. But it is true that there are a lot of people who have a law degree in the Parliament. Quite a number of my colleagues in Cabinet have got a law degree but have not practiced. And they would say it's a pretty useful qualification.
Yeah, and a couple of years under your belt practicing.
Yeah.
Turbocharges that learning, but let's move on. Sean McAuliffe was a guest in this series last year. There's someone with a law degree who uses it every day to make fun of people in power.
Yes.
Yeah, without getting sued for it. Question from our online audience: are lawyers being taught to uphold social justice, or is it about finding a loophole to earn top dollar?
There's the full range of human experience is demonstrated in people who graduate in law, and the full range of orientations to what you are going to do in life. And I would say a much higher proportion of law graduates are interested in human rights and social justice issues than the rest of the population, even if some of them think that their life will be spent in mergers and acquisitions and not in human rights. But I do think that the law degree teaches you a real interest in issues of justice. And I see it in the pro bono effort that the profession puts in. Very often I've been told by partners at the big firms that one of the reasons they run pro bono programs is because that is what the young graduates who come to work in those firms expect. And one of the things they are looking for in the firm is that the firm is making a pro bono effort, is making a contribution in a range of other ways, because they want to work as well as learning their trade in whatever area of the law the firm is going to teach them about or wants them to specialise in. They want to work in some pro bono way.
I've got a whole lot of topics here I want to cover, and we're not going to have time. I want to talk about judges. I want to talk about the AT. I want to talk about a whole lot of other things. But you're in an incredibly special position in the room when it comes to discussing the voice, the statement from the heart, and whether or not we're going to have an Indigenous representation in the Constitution, the referendum process, and then leading after that to treaty, according to your party in government, your model. Others have a view, in particular the Greens and Lydia Thorpe have a view that things should be done in a different order, but they're not in government, you are. I think at the recent meeting of more than 40 First Nations leaders in Canberra, convened by Linda Burney and Pat Dodson,
we've got, I attend that.
You were the only white person in the room for the day.
We have two groups. We have an Indigenous leaders working group, and we have a wider consultation group of there's about 20 Indigenous leaders from all around Australia in the first group, and then there's a wider consultation reference group with about 50 to 60 Indigenous community people from around Australia. And it has been a great privilege to participate in this. As Linda would put it, the only white fella in the room.
And what is your role?
I'm there because I'm the Attorney General.
But are you giving legal advice? Surely not.
I'm certainly not giving legal advice. We've got another group called the Expert Constitutional Group with 8 very eminent Australian lawyers on that group who are there to answer questions if the working group has questions.
About constitutional reform.
About legal issues that come up in these discussions. These working groups are there to advise the government. They are there to provide direct input from the Indigenous people of Australia to the government. And my role is to listen and perhaps to answer questions if they come up. It's certainly not to provide legal advice.
So I'm still not clear though. It's not as if you haven't got enough to do. You know, a reforming Attorney General, Cabinet Secretary, occasionally you're supposed to represent the constituents of the seat of Isaacs as well. But
I do.
Somewhere along the way. And then you're supposed to fit in this key role on what, without being too emotional about it, is probably the most significant reform in the lifetime of most of us in this room. And I'm not sure why you're there.
Because the government puts immense priority on implementing the Uluru Statement from the Heart and on this referendum. We have not held a referendum in this country since 1999. We have not had a successful referendum in this country since 1977. So unless you're 40 and over, you haven't voted in a referendum. Unless you're 60 and over, you haven't voted in a successful referendum. We want this referendum to succeed. We think that recognition of our Indigenous peoples is long overdue. The Uluru Statement from the Heart showed us the way in which we can achieve this, and the Prime Minister and everyone in the government is determined to make this happen. And that's why I'm in the room, John. And it is worth me devoting time to this. The Prime Minister and my Cabinet colleagues want me there, along with the Minister for Indigenous Australia, Linda Burney, and the Special Envoy, Senator Patrick Dodson. And I'm very pleased to be there with them.
I'm very pleased you're there too, and I regard it as a sort of a reassurance, but there are people in the Indigenous community saying, what's he doing there? There are people saying, what, is he there because they don't... But I have had conversations with people who have said, they obviously don't trust Linda and Pat because they've got to have Mark sitting there making sure they don't get it wrong.
On the contrary.
Well,
I am there
put it to bed.
I am there to support. I am there to assist. And that is understood by everyone in the room. And I have not had the slightest suggestion that I shouldn't be there. I'm there to answer questions if they come up. And I'm there to work, as I have been, every day with Linda Burney and Patrick Dodson to make sure that this referendum is a success. And we're expecting, as the Prime Minister has said, the referendum will take place sometime in the next financial year. In other words, after the 1st of July next year.
So I have a deep personal commitment, which I expressed at the start, and saying I have a personal view that I've formed over my years of interacting on these issues that we have to do it. But there are people who are just as convinced and just as invested in saying we must not do it. What do you do to try and make sure this is not a divisive debate like the same-sex marriage referendum? Oh, sorry, non-referendum, same-sex marriage public opinion poll.
I don't think it's possible to hold the marriage equality plebiscite, which I didn't support, the holding of. I was pleased that we got to the 65% yes vote, but it wasn't necessary. It might have been necessary for internal Liberal Party purposes.
It clearly was.
And Malcolm Turnbull would point to marriage equality as an achievement of his term as Prime Minister. But the route that he had to follow to get there by holding this, what was a very divisive period for Australia. And
insisted upon and designed by Peter Dutton.
Echoes of it are still washing through in the debate that we've had over the religious discrimination legislation. And that's an unfinished piece of business still to come.
It's on the list.
But referendums are, and we did not need to hold a marriage equality plebiscite, but we do need to hold a referendum in order to change our constitution. That's what section 128 of the constitution tells us. I think, and I've thought for a long time, that recognition of Indigenous people in our constitution is the topic most likely to succeed as a referendum topic. And so I'm very pleased that the very first attempt we are making after a long gap, I used to say in the first decade of this century, this is the first decade in which we have not attempted to change our constitution. Then in the second decade, I was able to say it's been 2 decades. Because if you look at the long history of mostly unsuccessful attempts to change our constitution, we have tried in every decade of the 20th century. And then we stopped. Now we need to get back in the habit of amending our constitution. The framers of our constitution intended that it be able to be changed. They might have made it hard with the double majority that's required, but they intended that there be attempts to change it when society changes, when there was a need. And I'm very, very much hoping that this topic, recognition of our Indigenous peoples, is the right topic to get people back in the habit of changing the constitution, because there are a number of other changes that we might like to consider.
Further down the track.
So
you're trying to
not at the same time.
No.
One of them is long-standing Labor Party policy, which is 4-year terms.
Yep.
We've had attempts twice in the history of our federation to move to 4-year terms for the
and
House.
fixed election dates.
Yeah, well, that too. But we've had 2 attempts in the past to go to 4-year terms for the House of Representatives. They both failed, and we should try again, because when we last tried in the 1980s, no state or territory had 4-year terms, fixed 4-year terms.
Yeah, sure.
And now every state and territory has, the last one being Queensland, but which has just held its first election for a fixed 4-year term. I think Australians have now got into the habit of thinking about elections as appropriately fixed and appropriately over a 4-year term. They can see the benefits that have been gained by moving to that. I'd like to think that sometime in the next decade or so, we will have a referendum to establish a 4-year term.
And then you have 8-year terms for senators.
No,
that's a long time.
No, I'm not in favour of that, but that's a debate.
Do you want to shorten the term for senators?
There's 2 models.
There's a few I can think of whose terms should be shortened.
You know this. New South Wales opted for the 8-year term model, and Victoria opted for the 4-year term model for their upper house.
Yeah.
Queensland got rid of their upper house in 1923, so issue doesn't arise for them. And I personally favour the 4-year Senate term, and I appreciate that serving senators will probably not agree, because presently they have 6 years.
Let's move away. We moved away from where we were,
did.
which was talking about resolving the issue. And then there's the argument, and we've seen polarisation of politics over Brexit, over Donald Trump, and we can go on a Cook's tour of the world and look at all the right-wing backlash, but a lot of it's about race. Brexit, I've always thought, was about immigration. Italy, we've just seen a right-wing government elected, which is also about immigration, and so on around the world. The issue of race, as opposed to immigration, can be weaponised by the emerging right in the near future in Australia in the context of the referendum process you're talking about. What does your government do to counter the likelihood of that?
I don't want to be too starry-eyed about Australia. There is a strand of racism in our country. Noel Pearson talked about this in his wonderful
Boyle lecture last
first
week.
Boyle lecture last week, and I'm looking forward to the remaining lectures in the series.
Can't recommend it enough if people haven't caught it yet.
Noel is right to speak about that strand of racism in our society. But equally, when we say that this is the most multicultural society on earth, that's a fact about our society. There is no other country where half of the people of Australia have at least one parent, have of their country, one parent born overseas. The Americans like to call themselves a melting pot, but their like statistic is about half. It's only about a quarter of Americans who had one parent or more born overseas. And the level of acceptance, and I said in a speech today, I've moved away from using the word tolerance. I now like the word acceptance because I think tolerance has a degree of grudgingness about it. I want more than tolerance. I want acceptance. I want understanding. And we have acceptance and understanding in Australia overwhelmingly. This is me being starry-eyed now. But I do think that there is a wonderful aspect to Australian society where we do have people from 200 countries. We do have people with hundreds of languages. And I represent a particularly multicultural electorate in southeast Melbourne, but it's a bit of a competition in the federal parliament. People like to say my electorate's more multicultural than yours. But most electorates in Australia, because most communities in Australia are very multicultural, living with a degree of acceptance where it's been understood that we must fight against racism. And one of the priorities for our government is going to be to restart the Racism It Stops With Me campaign that I thought had some success. I quite like it as a slogan. It's saying everybody is responsible for speaking out when you see racism, when you hear racism, and picking people up when you see it. I think we've made tremendous strides in Australia. To think that we started the last century, we started our federation with a white Australia policy, and to look at modern Australia, to start with the moving away from the white Australia by the Holt government, the completion of the move by the Whitlam government, and we really haven't looked back in that time. It's been a good 50 years. I spoke in the speech today about the passage of the Racial Discrimination Act by the Whitlam government. It's called the Enderby Lecture, and it's
Kep Enderby.
Remembering Kep Enderby, who was briefly the Attorney General at the end of the...
After Lionel Bowen,
the end of Lionel Murphy. After Lionel Murphy.
After Lionel Murphy, before Lionel Bowen.
Before
Bowen
Lionel
came later.
Yes. And Enderby, one of Enderby's tremendous achievements was the passage of the Racial Discrimination Act, which was the first of the Australian anti-discrimination statutes, followed in 1983 by the Sex Discrimination Act, then the Disability Discrimination Act, and finally the Age Discrimination Act. And I think these have been great achievements of successive Australian governments. 3 of those acts are achievements of Labor governments, but one of them is of a Liberal government. And there is overwhelmingly, I think, a bipartisan commitment to ending discrimination in all its forms.
We've only got a minute left. Are you glad you didn't become a judge?
Yes.
You'd have been
people
so
ask
bored.
this question. No,
You'd have been so bored.
I admire people who have the temperament to be judges.
And you had the opportunity.
Perhaps, as a senior barrister and as a moderately successful senior barrister.
And with a Labor government in power in the state.
If I'd stayed as a barrister, I might have been offered a position on the bench. But I know myself, I think, well enough to know that I've got a terribly partisan temperament. and I've been happy serving my community in the federal parliament. And I suspect much happier than I might have been as a judge. I look at some people I know who are judges who wanted to be politicians and didn't end up as politicians. And to an extent, they're a bit frustrated.
Well, I think it's been wonderful to hear you being able to expand on so many areas in your control. Could you please thank Mark Dreyfus, the Attorney General?
Thanks, John.
And next week, same time, same channel, Amanda McKenzie from the Climate Council for Monash Law in Conversation. Thank you for joining us this evening.
Thank you.